What the heck?
What did I do?
What the actual heck?
What did I do? I'm asking you, what did I do?
Take a moment. Just take a moment and watch that. A woman, hands already in the air, children in the car, multiple officers, guns drawn, and she's the one asking questions calmly, repeatedly, what did I do? And they can't answer her. Not because it's a complex situation, not because the answer is classified. They can't answer her because the honest answer would be, we don't actually know.
What the heck?
Girl, you said.
I'm recording. What? Is this? We have a kid in the car.
I have a baby in the car.
That's fine. Listen to me.
Put your gun down. What did I do? But what did I do?
I'm not arguing with you.
But why am I being stopped?
That right there, that 4-second exchange tells you everything you need to know about how this system operates when black people are involved.
Hands up and walk back here.
What the heck is going on?
Like,
What?
Like, what I need you to do is listen.
But right,
Tell you to do. Does it
Her hands are up though. What? Are they crazy?
this is a
Oh my gosh.
Don't step out for me.
Oh my gosh. What the heck? I'm keeping my head. I'm staying recording, by the way. What the heck is going on? What? Baby in the car, by the way. What is going on? Okay. Wait, hold on.
No, you good.
Wait, what happened? Attempted what? We just went.
Where were you guys coming from?
Wait, we just came back from the house just now.
Yeah. Where's your house at?
Denoso, like Polo Ranch. Polo Ranch. Okay. Wait.
Before we go any further, if you are new here, hit that subscribe button right now. We cover stories like this one daily. And drop a comment below, tell me where you are watching from. Here's what I want you to understand by the end of this video. What happened to Kathleen Booker on April 3rd, 2026 in Fulshear, Texas was not a mistake that exists in isolation. It was a predictable outcome of a policing culture that treats proximity to blackness as proximity to guilt. And the legal framework that is supposed to protect citizens from exactly this kind of encounter has been so systematically weakened that officers can do almost everything we saw in that video and face virtually no consequences. That is not an opinion. That is the architecture of the law as it currently stands. And we need to talk about it. So let's start with the facts, because facts matter. Especially when someone's going to come into the comments and say, we don't know the full story. We actually do. On the morning of Good Friday, April 3rd, 2026, Kathleen Booker, a Houston area realtor, a mother, left her home with her stepdaughter and her 2-year-old toddler in the car. Routine. Ordinary. The kind of morning millions of people have every single day. What happened next was anything but ordinary. The Fulshear Police Department was responding to a report of a gas station robbery on FM 1093. According to their own press release, the suspects were described as 2 black male individuals armed, wearing masks, who fled in a white Nissan vehicle. Officers spotted a white Nissan in the area. And that apparently was enough. They conducted what the department calls a high-risk felony stop. Multiple patrol SUVs, officers with weapons drawn, commands being shouted. Booker stepped out of her vehicle with her hands already raised, asking what she had done wrong. A female officer handcuffed her. Her stepdaughter was ordered out of the car. Officers then found Booker's toddler in the back seat. She was detained, she was searched. Her children watched all of it, and then once it became clear that none of this made any sense, she was released. No arrest, no charges. According to Booker, no apology at the scene either, though Fulshear PD disputes that. Let me be precise about what was wrong here. The suspects were male, Booker is a woman, the suspects were described as wearing masks. Booker was not. The vehicle type reportedly did not match. And Booker's own Instagram caption, which has since received nearly 500,000 likes, laid it out plainly. Different vehicle type, different race from the description given, different gender. And still, she was detained. Now, I want to be careful here because some people will hear this story and think, isolated incident, one bad department, unfortunate mistake, move on. But the data and the documented history will not allow us to do that. This is not the first time. This is not the 10th time. This is a pattern so established, so recurring, that journalists covering this story were able to immediately pull 3 comparable incidents from recent years without even trying hard. In 2021, a North Carolina woman pulled into her grandmother's driveway after a gym workout. Police surrounded the car and placed her under arrest for attempted murder. The reason? A misspelled name entered into a license plate reader system led them to the wrong person entirely. In 2023, a 12-year-old boy was detained while taking out the trash. Officers said his clothing matched a robbery suspect's description. It took his father coming outside to make police realize they had the wrong child. And just last year, an 11-year-old girl in upstate New York was arrested during a traffic stop, mistaken for a car thief. Cell phone video showed her crying as her friends tried to defend her during a police interrogation, 11 years old. When the same type of incident, wrong person, black person, high force response, minimal justification keeps repeating across different states, different departments, different years, at what point do we stop calling it a mistake and start calling it a feature? That is not a rhetorical question. I am genuinely asking, because the research on implicit bias in policing is extensive. Studies consistently find that black individuals are more likely to be stopped, more likely to have force used against them, and less likely to be given the benefit of the doubt during ambiguous encounters compared to white individuals in statistically similar circumstances. Kathleen Booker herself said it best. I have a clean record, and if this is what I experienced, I can only imagine what others go through every single day. That sentence should stop you cold, because she's not wrong. Now, I want to shift gears slightly, because I think this is where the conversation usually gets dropped, and it shouldn't. Let's talk about the law. Booker's attorney, Audia Jones, has stated publicly that her client's Fourth Amendment rights were violated. The Fourth Amendment to the United States Constitution protects citizens against unreasonable searches and seizures. It requires that any detention, any stop where you are not free to leave, be grounded in what the law calls reasonable suspicion at minimum and probable cause for an arrest. So the question becomes, did officers have reasonable suspicion to conduct a high-risk felony stop on Kathleen Booker? Here's where it gets complicated and where the legal system, as it currently functions, will not necessarily deliver the justice that common sense demands. Courts have historically given law enforcement enormous deference when it comes to Terry stops, that's the legal term for brief investigative detentions, stemming from the 1968 Supreme Court case Terry v. Ohio. Under Terry, officers can stop and briefly detain someone if they have reasonable, articulable suspicion that criminal activity is occurring. The standard is not probable cause. It is lower than that. Now, Fulshire PD's argument will essentially be, we received a robbery call, we observed a vehicle matching the general description near the area of the crime within a close time window, and we acted on that information. They will argue that those facts, taken together, gave them reasonable suspicion. And here is the uncomfortable truth. Depending on the judge, depending on the circuit, that argument might actually hold in court. This is not me defending what they did. I want to be very clear. This is me explaining why the legal path forward for Booker, as righteous as her cause is, will not be simple. There is also the issue of qualified immunity. Qualified immunity is a legal doctrine that shields government officials, including police officers, from civil liability unless they violated a clearly established law. In practice, what this means is that even if a court finds that officers violated Booker's constitutional rights, they may still be protected from personal liability if no prior case established with sufficient specificity that this exact type of conduct was unconstitutional. Critics of qualified immunity, and there are many across the political spectrum, argue that the doctrine creates a circular trap. Officers are immune unless there's a prior case, but prior cases are often dismissed because of immunity, so the clearly established bar is almost impossible to clear. It is, in the words of many legal scholars, a doctrine invented by the courts with no basis in the original text of the civil rights statutes it interprets. For Booker specifically, her strongest legal argument may lie in the clearly documented mismatch between the suspect description and her actual profile. 2 black males with masks, 1 black woman with children. If that gap is wide enough, and legally it arguably is, her attorney can make a compelling case that no reasonable officer acting in good faith could have identified Booker as a valid suspect. That is the wedge that could potentially pierce qualified immunity. She will also need the video. And fortunately, critically, she has it. The footage recorded by her stepdaughter is one of the most important legal assets in this case. It contradicts the department's claim that weapons were never pointed at occupants. It documents the timeline. It captures Booker's compliance from the first moment she stepped out of that vehicle. In civil rights litigation, video evidence has repeatedly proven decisive. Not always sufficient, but decisive. Fulshear PD issued a formal statement, and I want to read part of it carefully, because the language they chose is revealing. They said, and I'm paraphrasing closely here, that officers made rapid decisions based on limited and evolving information, that the stop was based on a reasonable match to the suspect vehicle description, combined with the vehicle's proximity in time and location to the reported crime, and that their officers acted in good faith in accordance with training and department policy. Good faith in accordance with training. That last part is important. Because if this stop was consistent with their training and their policy, then the problem is not one officer having a bad day. The problem is systemic. The problem is institutional. And that actually strengthens the case for broader accountability, potentially including the department itself, not just individual officers. There is also something telling in what the department did not say. They did not say, "We are reviewing our procedures to ensure this doesn't happen again." They did not say, "We recognize the harm caused to this family." They defended the stop fully. And they noted that Booker's husband, who met with a supervisor, did not ultimately file a formal complaint, which, let's be honest, may have been the desired outcome. No complaint on record. No internal investigation triggered. Case quietly closed. Booker's decision to go public, to post the video, to speak to Isaiah Carey on Fox 26, that decision changed the calculus entirely. It forced a public response. It created a record. And it is precisely the kind of accountability that the formal complaint system by itself often fails to produce. I want to close with something broader, because this story is about Kathleen Booker, but it is also about every black person who has been in a car and felt that specific, particular fear when lights appear in the rearview mirror. It is about the mental math that black drivers do instinctively, automatically, that other drivers simply do not have to perform. Where are my hands? How do I sound? Will this officer decide that my presence alone is suspicious? Booker wrote on Instagram, "I'm tired of feeling alone in moments like this." She is not alone. And the fact that she chose to share as a self-described private person who normally keeps these experiences to herself tells you something about the weight of carrying this, about how exhausting it is to absorb these encounters in silence and simply continue on. The commentary around this story has also been revealing. Multiple black women who covered this story on television, on social media, immediately said some version of the same thing. "I have been here. I know this feeling. This could have been me." That kind of immediate, widespread recognition is not coincidence. It is the lived experience of a community that has been navigating this reality for generations. And for viewers who have not personally experienced this, who are watching to understand rather than to recognize here, what I need you to take away. The danger in these situations is not hypothetical. It is not abstract. When officers approach with weapons drawn, based on a description that does not match, the margin for a fatal error is real. Booker complied. She kept her composure under extraordinary pressure, with her children watching, and she is here to tell this story. Not everyone has been that fortunate. Kathleen Booker has retained an attorney and is in the early stages of pursuing legal action against the Fulshear Police Department. That process will be long, it will be difficult, and the outcome is not guaranteed. But her willingness to go public to put her face and her story on record matters. Documentation matters. Video matters. Legal representation matters. And community attention, the kind that makes it impossible for departments to quietly close a file and move on, matters more than people realize. If you found value in this breakdown, share it. Not for the algorithm, though, that helps, but because someone in your circle may be navigating a situation exactly like this one and not know what rights they have, what recourse they have, or that they are not alone. We will keep watching this case. We will keep covering these stories, because the moment we stop paying attention is the moment they stop being accountable. Stay informed, stay grounded.
What? Oh, by the way. What is going on? Okay. Wait, hold on.
No, you good.
Wait, what happened? Attempted what? We just went.
Here we go. Here we go. Where were you guys coming from?
Wait, we just came back from the house just now.
Where's your house at?
Denoso, like Polo Ranch.
Polo Ranch?
Polo Ranch.
Okay. So, guys,
Okay. Wait.
I'm talking to you too.
On April 6th, 2026, in Osceola, Arkansas, a small city about 50 miles north of Memphis, Tennessee, a man was sitting in his wheelchair outside his apartment building, minding his business, worried about his family, when the person who was supposed to protect him walked up and slapped him across the face. That man's name is Denarius Williams.
That right there is why you're going to go to jail. You're not going to talk to me like that. I'm talking to you too.
He has been paralyzed from the stomach down since 2013 when he was shot in the back. He cannot feel or move anything below his belly button. He cannot stand. He cannot run. He cannot defend himself from the waist down. And the person who slapped him was not a stranger with a grudge. It was the chief of police. Before we go any further, if you are new here, this channel is where we talk about racism, power, and the consequences that follow when communities refuse to be silent. Hit that subscribe button right now and drop a comment below telling me where you are watching from. I want to know if you are tuning in from Atlanta, from London, from Lagos, wherever you are, tell me. Now let us get into it. The night of April 6th, 2026, police were called to the Hyatt Apartments in Osceola. The call was about teenagers fighting nearby. That is why officers showed up.
Already knew it was on. Already knew it was on. Already knew, baby. When that
That was the assignment. Denarius Williams was not part of that call. He was not fighting. He was not a suspect. He was a father and a husband sitting outside his home in his wheelchair, and what he found out when officers arrived was that his wife and his son had been handcuffed and detained. Now, ask yourself honestly, if that were your family, what would you do? You would want to know what was happening. You would want answers. That is all Denarius Williams wanted. During the response, the newly appointed chief of police, Robert Bobby Eflin, walked up to Williams. Words were exchanged. Williams, by his own account, told the chief to get his finger out of his face. He admitted he used some strong language. He said he told the chief to get his hands off him and to move his finger from his face. But he was clear. He did not touch the chief. He did not strike him. He fanned a hand away from his personal space. That is it. What happened next is on video. Eflin slapped Denarius Williams across the face. Then he reached around from behind and choked him. A paraplegic man in a wheelchair, who cannot move from the belly button down, was slapped and choked by the chief of police in front of his neighbors, in front of witnesses, with a camera pointed directly at him. Williams described it this way. He said he was smacked hard, and then choked. He said he felt helpless, belittled, embarrassed, and powerless. Think about what it means for a man who has already had his body taken from him once by violence, a gunshot that paralyzed him for life, to then sit in that same body and be struck by the highest-ranking law enforcement officer in his city, in front of his community, in front of his family, with nowhere to go and no way to defend himself. Here is the detail that makes this story even harder to sit with. Robert Bobby Eflin was sworn in as Chief of Police of Osceola, Arkansas on March 26, 2026. The incident at the Hyatt Apartments happened on April 6, 2026, 11 days. He had been Chief of Police for 11 days. 11 days into the job, this man handed authority over an entire community, given a badge, a title, and the public trust walked up to a wheelchair-bound paraplegic and put his hands on him. When the video went viral, Mayor Joe Harris came out and said he was shocked. He said, and I am paraphrasing here, that when he saw the footage, he could not believe it, because Bobby Eflin is not that kind of person. He said Eflin is at the school every week, working with kids. He suggested that Williams must have said or done something to provoke the chief. And I want to be careful here, because I want to be fair. I understand that a mayor who just hired someone does not want to believe the worst. But here is my problem with that framing. It does not matter what Denarius Williams said. It does not matter if he cursed. It does not matter if he was loud, emotional, or confrontational. His wife and child had just been detained by police. He was scared and frustrated. None of that, not a single word of it, justifies a police officer slapping a paralyzed man in a wheelchair and then choking him. There is no version of anger that makes that acceptable. There is no provocation that makes that defensible, and leaning on Eflin's reputation at the school does not erase what the camera captured. Now here's the part of the story that I do not want you to miss, because it reveals something important about how this night unfolded. Stephanie Williams, Denarius Williams' wife, was the one who called the police. She called them. She was trying to protect her family because something threatening was happening near their home. She reached out to law enforcement in good faith. She ended the night in handcuffs. Stephanie was arrested and charged with disorderly conduct and endangering the welfare of a minor. Her 15-year-old son was also arrested. She told reporters she had tried to intervene when she saw tensions rising. She said she tried to grab her son when she saw a school official with a gun pointed at him. She called the police. She ended up in jail. Her paralyzed husband was assaulted by the chief. Her teenage son was arrested, and the man responsible for all of it had been on the job for 11 days. That is not just excessive force. That is what the complete collapse of institutional trust looks like for a black family in a small American city. A woman trusted the system enough to call for help, and the system punished her for it. Now, let us talk about accountability, because feelings alone do not change anything. Structures do. Laws do. Charges do. Under Arkansas law, what Eflin did could meet the threshold for battery in the 2nd degree. That applies when a person purposely causes physical injury to someone they know to be unable to resist. Denarius Williams cannot stand, cannot run, cannot raise a leg, cannot fight back from a seated position against a standing officer. A jury hearing those facts could reasonably conclude that Eflin knew exactly who he was dealing with when he struck him. Battery in the 2nd degree is a Class D felony in Arkansas. That carries up to 6 years in prison. The choking is a separate legal matter. Any officer applying a chokehold to a civilian who has not been established as a physical threat faces an extremely difficult legal justification regardless of what words were exchanged. This was not a domestic situation. This was a uniformed police chief applying force to a member of the public during a call response. Under the 4th Amendment, when a police officer uses physical force against a civilian, that constitutes a seizure under the law. The controlling legal standard comes from a Supreme Court case called Graham versus Connor, decided in 1989. Courts look at 3 things: the severity of the crime at issue, whether the person poses an immediate threat, and whether the person is actively resisting or trying to flee. Denarius Williams was not under arrest. He was not charged with anything. He was not threatening anyone. He was asking about his family. A man in a wheelchair who fanned a hand away from his face is not an immediate threat under any honest reading of that standard. There is also a civil rights dimension here. Under Section 1983 of the Civil Rights Act, any person acting under color of law who violates someone's constitutional rights can be held personally liable. Eflin was in uniform. He was acting as chief of police. The video, Williams' account, and witness statements form the foundation for a civil lawsuit that Williams and his attorneys would be well within their rights to pursue, and the Americans with Disabilities Act applies here too. Title II of the ADA requires law enforcement to make reasonable modifications when interacting with members of the public who have disabilities. Williams' paralysis was not hidden. He was visibly seated in a wheelchair. The decision to escalate physically against someone anatomically incapable of posing a conventional physical threat is exactly the kind of conduct that law is designed to address. By April 7th, 2026, the video was everywhere. Mayor Harris called for an independent review by an outside agency. He said appropriate action would follow. By April 8th, 2026, less than 48 hours after the video went viral, Bobby Eflin submitted his resignation letter. In it, he said it was best for him and his family to step away from service. He expressed gratitude for the opportunity and offered to assist with a smooth transition. No acknowledgement of what he did. No direct apology to Denarius Williams. Just a quiet exit. Wells Skaggs has since taken over as interim chief of police. I need to be direct with you about something because I think it is tempting to see a resignation and feel like justice happened. It did not. A resignation is not a conviction. It is not a criminal charge. It is not a civil settlement. And here's the part that should concern you in this country. There is a well-documented pattern of officers with histories of misconduct moving from one department to another. Researchers and advocates call it the wandering officer problem. The national systems designed to prevent it, including the National Decertification Index, are incomplete, voluntary in many states, and not consistently checked by hiring agencies. Without a criminal record or a formal disciplinary finding entered into law enforcement databases, nothing legally prevents Bobby Eflin from applying for a law enforcement position somewhere else tomorrow. He could show up as chief in another small city. That is not a hypothetical. That is a documented pattern across American policing. The independent investigation currently underway is therefore not a formality. It is the mechanism that either creates a permanent record or allows a clean exit. If investigators refer criminal charges to the prosecuting attorney and the evidence on that video suggests they should, it creates a record that follows Eflin. Without it, his resignation is just a door closing quietly behind him. The community of Osceola is not asking for anything complicated or unreasonable. They want the investigation to be real and thorough. They want criminal charges considered. They want the arrests of Stephanie Williams and her son reviewed for legitimacy. And they want to understand how a man became chief of police and 11 days later put his hands on a disabled man in front of their homes. Denarius Williams was shot in the back in 2013 and has lived in a wheelchair ever since. He has spent over a decade carrying the weight of a body that violence took from him, and on the night of April 6th, 2026, while worried about his wife and his son, he sat in that same chair and was struck across the face by the man the city of Osceola had just handed the most powerful law enforcement position in town. The neighbor who recorded that video made a choice to point her camera and keep it there. The community that gathered that night made a choice to be witnesses. And the reaction visible on that recording, the shock, the outrage, the voices rising, makes clear that what they saw did not look like law enforcement. It looked like a man with a badge abusing a man with no ability to defend himself. The question this case leaves open is not whether what happened was wrong. That part is settled. The question is whether the systems built to respond to it will actually do their job, a transparent investigation, criminal charges if the evidence warrants them, and a record that follows Bobby Eflin wherever he goes next. This channel will stay on it. When there is a development worth reporting, you will hear about it here. If this video found you, share it with someone who needs to see it. Subscribe if you have not already, and drop that comment below. Tell me where you are watching from, and tell me what you think accountability actually looks like in a case like this. I will see you in the next one.
Grab me.
Well, we're telling you, giving you lawful order. If you don't get out, you're about to get ripped out of the car.
Well, go ahead.
So don't.
I got a back problem. Don't rip me out.
I'm not trying to do that. So come on out. Come on out. We'll explain it to you.
We're gonna tell you, dude. Come on, step out of the car.
Let me go.
No, I'm not letting you go.
Bro, let me
This is
go,
your last
bro.
chance, man.
No.
Get the fuck out.
Get out.
Get on the ground. Get on the ground. Get on the ground.
Hands behind your back.
In August, a 42-year-old black grandfather in Summerville, South Carolina, drove away from his relative's home and within minutes was grabbed by the throat, punched in the face, and arrested.
Pull him up in the trunk.
You got your camera.
We got a camera, bro.
The package that supposedly justified the stop, it was still sitting on the porch where the police had left it. Not in his car, not in his hands. On the porch. This episode covers unreasonable traffic stops, excessive use of force, unlawful vehicle searches, and the constitutional protections that were violated at nearly every stage of this encounter. We will walk through each one carefully because what happened to Timmy Miles is not just an outrage. It is a legal education. Before we go further, if you are watching this and you care about understanding your rights and holding law enforcement accountable, subscribe now and hit the notification bell. This channel exists to give you the legal knowledge to protect yourself and your community. Share this video. Knowledge is the first line of defense. To properly analyze this encounter, we must first understand the operation that preceded it. Law enforcement agencies frequently employ a tactic known as a controlled delivery. Charleston police had intercepted a FedEx package containing marijuana addressed to a residence in Somerville. The package was addressed to an individual who did not reside there, and Timmy Miles, who was visiting the home to see family, had no knowledge of it. Officers from the Somerville Police Department delivered the package to the front porch of the residence and stationed surveillance officers in a wooded area nearby to observe who would take possession of it. This is a lawful and established investigative technique. The legal theory is straightforward. Whoever knowingly takes possession of a package containing contraband can be charged with receipt of that contraband. However, the operation's integrity depends entirely on officers maintaining continuous and reliable observation of the package. That did not happen here. The officers lost sight of the package. At roughly the same time, Timmy Miles left the residence. Corporal Robert Barano concluded without any confirmatory evidence that Miles must have picked up the package. That conclusion, drawn without a single piece of articulable evidence, became the basis for everything that followed. The Fourth Amendment to the United States Constitution protects individuals against unreasonable seizures. A traffic stop constitutes a seizure under the Fourth Amendment, and to be constitutional, it must be supported by at least reasonable suspicion, a standard established by the Supreme Court in Terry v. Ohio in 1968. Reasonable suspicion requires that an officer be able to point to specific, articulable facts that, taken together with rational inferences, reasonably suggest that criminal activity is occurring. Critically, it is an objective standard, meaning a court will ask not merely what the officer believed, but whether a reasonable officer in the same circumstances would have held that belief. Here, the only basis for stopping Timmy Miles was that officers had lost sight of a package and Miles had left the property around the same time. Miles had not been seen picking up the package. No surveillance footage captured him taking it, no officer witnessed him handle it. The package, as it would turn out, had never moved. It was still on the porch. Under these circumstances, Miles would have a strong argument, and his attorneys did make this argument, that the traffic stop was not supported by reasonable suspicion and was therefore unconstitutional from the outset. The Supreme Court held in Pennsylvania v. Mims in 1977 that officers may order a driver to exit a vehicle during a lawful traffic stop as a matter of course without requiring any additional justification. This was extended to passengers in Maryland v. Wilson in 1997. However, and this is critical, the lawfulness of that order depends on the lawfulness of the underlying stop. If the stop lacks reasonable suspicion, the order to exit may itself be unlawful, and a defendant could potentially argue they were not required to comply. That said, courts have generally been reluctant to extend the right to resist even unlawful police orders, particularly in the Fourth Circuit, which governs South Carolina. Section 16-5-50 of the South Carolina Code limits the hindering statute to interference with arrests. However, a Somerville municipal ordinance makes it unlawful to refuse to obey a lawful order of any police officer engaged in official duties, giving Miles a potential defense if the underlying stop was unlawful. Now, assuming for the sake of analysis that the stop was lawful, what level of force may an officer use to remove a non-compliant driver? The Fourth Circuit addressed this directly in Armstrong v. Village of Pinehurst in 2016, holding that non-compliance with lawful orders justifies some use of force, but that the level of justified force varies based on the risks posed by the resistance. The distinction between active and passive resistance is central here. In the 2022 case of Nazario v. Gutierrez, the Eastern District of Virginia held that verbal refusal to exit a vehicle constitutes purely passive resistance. Timmy Miles verbally refused to exit. He expressed confusion and asked for an explanation. He made no threatening movements. He did not attempt to flee. He was, by every observable measure, passively resistant. The Fourth Circuit has been clear that passive resistance does not justify severe force. In the 2020 case of Wilson v. Painter, the court denied qualified immunity to an officer who delivered a single closed-fist strike to the face of a driver who had failed to comply with 4 consecutive orders to exit his vehicle, noting that the driver had made no threatening or evasive movements and that the officer had blocked the door. In a 2021 appeal, the Fourth Circuit affirmed that denial. Barano waited approximately 35 seconds before using force, slightly longer than the officer in Wilson, but used significantly more force. He grabbed Miles by the throat, choked him, and punched him at least twice in the face. The department's own separation documentation stated that there was no apparent imminent threat, that Barano's conduct was not objectively reasonable, and that it violated both departmental policy and state law. Another detective was observed grabbing Barano's arm in what appeared to be an attempt to prevent further strikes. Under these precedents, Miles has a strong constitutional claim that the force used against him was excessive and unreasonable. After Miles was removed from his vehicle, officers discovered that the package was still on the porch. The basis for the stop had evaporated. At that point, continued detention of Miles in handcuffs raises serious Fourth Amendment concerns. A seizure must be justified at every moment of its duration. Once the justification for a stop disappears, continuing to detain someone requires independent justification. The officers had none. Rather than releasing Miles, they requested a canine unit. The Supreme Court addressed canine sniffs in 2 key cases. In Illinois v. Cabales in 2005, the court held that a dog sniff conducted during a lawful traffic stop does not constitute a Fourth Amendment search. However, in Rodriguez v. United States in 2015, The court clarified that officers cannot extend a traffic stop beyond the time reasonably needed to address the original purpose of the stop in order to conduct a dog sniff absent independent, reasonable, articulable suspicion of additional criminal activity. Given that the basis for the original stop had already collapsed, and given that Miles was being held well beyond any reasonable traffic stop duration, the extension of his detention to await the canine unit is constitutionally problematic. The canine arrived and conducted a free air sniff of Miles's vehicle. It did not alert. Despite the negative canine alert, despite Miles's explicit and repeated denial of consent, and despite the absence of probable cause, officers proceeded to conduct an extensive search of Miles's vehicle, opening notebooks, folders, and containers throughout the car. The Fourth Amendment generally requires a warrant before officers may search a vehicle. Courts have recognized several exceptions, the most relevant of which is the automobile exception. Established in Carroll v. United States in 1925 and refined in Pennsylvania v. LeBron in 1996. If a vehicle is readily mobile and officers have probable cause to believe it contains contraband, a warrantless search is permissible. While the Fourth Circuit held in United States v. Sheets in 2002 that the odor of marijuana can provide probable cause to search a vehicle, there is no precedent establishing that a driver's admission to personal marijuana use without any evidence connecting that use to the vehicle, and in the absence of a canine alert, constitutes probable cause to search. Officers appeared to rely on Miles's admission as their justification. That justification almost certainly would not survive judicial scrutiny, particularly given that the canine had already sniffed the vehicle and found nothing. The search of Miles's vehicle was, in all probability, unconstitutional. Miles was originally charged with possession with intent to distribute marijuana and disobeying a lawful order. Both charges were dismissed, the drug charge dismissed in January of the following year, less than 5 months after the incident. Barano was terminated from the Somerville Police Department. He was subsequently arrested and charged with third-degree assault and battery. A judge found him guilty after a bench trial, sentencing him to time served. Miles filed civil rights lawsuits in both state and federal court. The state case was voluntarily dismissed. The federal case filed under case number 222, CV02789, was terminated in May of 2024, consistent with a settlement. Legal analysts estimated the potential value at over $1 million. No other officers involved in the incident were disciplined, not those who witnessed the force, not those who conducted the unlawful search, and not those who continued Miles's detention after the basis for the stop was proven false. The officers involved in this encounter receive an F, not solely for Barano's violence, but for a collective failure of judgment, integrity, and constitutional adherence that ran through every stage of the encounter, from an unjustified stop to an unlawful search, to a pattern of conduct that can only be described as an attempt to manufacture justification for harm already inflicted. Timmy Miles demonstrated a clear understanding of his rights, particularly his Fourth Amendment right to refuse consent to a vehicle search, which he exercised loudly and persistently. He receives high marks for that. However, in practical terms, citizens in similar situations may be better served by complying with officer orders in the moment, while clearly stating their objection for the record and pursuing legal remedies afterward. The courtroom, not the roadside, is where these battles are most effectively won. Understanding your rights matters. Knowing the law matters. And documenting every second matters. If this video helped you understand what happened and why it matters, please subscribe and share this video. Every view is a person who now knows more about their rights than they did before. That knowledge belongs to everyone, but it matters most in communities that have been systematically denied it. We will see you in the next episode.
On the ground! Get on the ground! Do you not listen? Get on the ground! Get on the ground! Get on the ground! Hey, let me see your hands. Bird, get on the ground! Get on the ground! Get on the ground right here! Get on the ground! You! Burgundy shirt, get on the ground! Over here! On the ground! On the ground! Get on the ground! Do you not listen? Get on the ground! Get on the ground! Get on the ground! There's a gun behind me. There's a gun, I believe, behind me.
I ain't got no gun, nothing.
Put your hands behind your back. Is there a gun back there?
Ain't no gun.
By that truck.
Ain't no gun.
You're not listening, dude. Bro, you got a gun on you, man?
No, I ain't got no gun. I don't
I'm just
own no gun. I don't
Turn
own
back over. Paul, do you watch him say? He had something.
I ain't own no gun.
The door's unlocked, the car was so.
No, he was right here. Watch him. Go watch him. There it is.
I don't own no gun.
All right, that's what he had. All right, who's the complainant? All right, get him up.
Put the leg up.
25 cents, got one tank.
Put the leg that way so you can stand up.
All right, listen, I'm about to help you. Hold on. All right, ready? 1, 2, 3. All right.
Yep.
Listen.
Yep, they slammed my head
Listen.
down on the cement. Yep.
Go back inside. Go back in the house. Go back in the house. Ain't nobody talking to you.
I got head drummer.
Go back in the house.
Yep. Y'all bust my head down. Yeah, I've been in an accident. Yep. Y'all bust my head down. You throw me down.
I sure did. You wasn't listening.
Yep. No, it ain't. You ain't to throw me down like that. I'm disability.
Okay.
I got head problem. Yep. You throw me down. Yep. You throw me down. You throw me down. Yep. You bust my head down on the cement. Yep. You bust my head.
All right, let me tell you what happened.
His forehead.
You bust my head down on the cement.
He was in front of the car when I came up. And he was walking like this. And I thought it was a gun at first. I said, drop the gun, drop the gun, drop the gun, drop the gun. Had him at gunpoint. And he's over here doing something like this.
You slam my head. You slam my
What
head
he was doing is
down
putting
on
this up behind the
cement.
tire. So he comes over right here. He got his hands in his pockets. I tell him, let me see your hands, let me see your hands, let me see your
Why you
hands.
bust my head then?
He wasn't listening.
No, it ain't.
He got the, like this right here,
You grab me.
and we went on to the
And
ground.
then you bust my head down
That's what
on the cement. You bust my
Yeah,
forehead.
your head did hit the cement.
Damn right, because you bust me down on the cement.
Where's the complainant?
You bust my head down on the cement.
Right here?
You bust my head. You bust my head.
Where's the complainant?
You bust my head down.
I'm trying to get the name of the complainant.
You
So,
bust my head. You bust my head down on the cement. If you ain't nobody, you got no. You bust my head down. Hell no. Yeah, bro. I'm gonna do this shit right here. Might be a beat on. Ain't nobody had no gun. I live right there. Ain't nobody had no gun. I ain't got no more on me. I ain't got nothing in me.
Putting your change right in your pocket.
Damn right. You slam me, you slam my head down. Okay. Yeah.
What do we do? Get Sam, come check him out.
Ain't nobody
There ain't nothing nobody here wanting to press charges on.
Who called?
I'm not sure.
Take him out of cuffs right now. I mean, because that's what we
You
got.
have to use it force.
Yeah.
No doubt.
Yeah.
slam my head down.
Dude, I didn't know what his
You
intention
use
was.
it force. You need to look at the camera.
Alright. The officer did wrong. Slam my head down. Bust my forehead. Damn right. You gonna pay me for that shit.
Mayor, I'm gonna take that in the evidence of what he had.
What?
Well, I mean, that's the reasons I did what I did. You know what I'm saying? That's where I'm coming from.
No gun or nothing.
Because when he was behind the truck, I couldn't see what he was doing, and I didn't know where
There ain't nothing there.
that went. If it was still in his pockets when he come around that car with his hands in his pockets.
His dogs on. No.
On camera.
Yeah, a dog
That's
stick.
fine.
A dog stick.
So he can come out of the cuff?
Yeah, take him out of here.
Yeah, he can come out.
You mind looking? Good, how are you? What's going on?
Officer slammed my forehead down in the cement.
Okay.
In the wrong place.
You can officers?
Yeah. Listen.
Can I get a card from you?
I don't have one there. We don't have
What's your
they
badge?
don't give us cards.
Okay, what's your badge number?
1059.
Let me see if I can get my phone. Hold on.
Hold on, we have cards.
I get Danny.
All right.
No.
Okay.
Thank
Go
you.
to the hospital?
Yeah.
All right. Call me.
Brandon, he can get his stuff off the car.
Will you say badge number?
1059.
On the 26th day of July, 2021, in Orangeburg, South Carolina, just after 5 o'clock in the afternoon, two men were doing something completely ordinary. Clarence Gayard, 58 years old, and his cousin Demario Julian were walking home. That is the entire story of what they were doing. Not running, not hiding, not causing trouble. Walking home on a summer evening in their own neighborhood. They never made it home without incident. Somewhere nearby, a call came into 911. Someone reported a man with a gun. Officers were dispatched to the Colleton Village townhomes, and when Officer David Lance Dukes stepped out of his patrol vehicle, he had already drawn his weapon before he had assessed a single thing about what he was actually looking at. What he was looking at was a 58-year-old man walking with a stick, not a firearm. A stick wrapped in shiny silver tape that Clarence Gayard carried everywhere he went, not as a weapon. As protection against the aggressive stray dogs that roamed his neighborhood. This was a man navigating his daily life with a makeshift tool, and Officer Dukes, gun already out, decided in a split second that it was a threat. Here is what Dukes did not know or did not bother to find out before escalating. Clarence Gayard does not move quickly. Years before this afternoon, he was struck by a vehicle while riding his bicycle. The impact left him with surgical rods and pins in his leg, his knee, and his hip. He walks slowly. He has no choice. His body will not allow anything else. None of that mattered to Officer Dukes. Before we get into this, hit subscribe and turn on notifications because stories like this one disappear fast. And I refuse to let that happen on this channel. Dukes ordered both men to the ground at gunpoint. Demario Julian, Clarence's cousin, complied, immediately dropped without hesitation. Clarence tried. He was doing his best. He was on his hands and knees, lowering himself toward the concrete as fast as his damaged body would allow. Anyone watching the body camera footage could see a man making every visible effort to follow the command. That was not fast enough for Officer Dukes. What happened next is on camera. Dukes approached Gayard while he was in that defenseless position, hands and knees on the ground, raised his right boot, and stomped down on Gayard's neck and head. The force drove Clarence Gayard's head into the concrete of the parking lot, a 58-year-old disabled man, on his hands and knees, attempting to comply. And an officer in full uniform brought his boot down on his skull. Clarence Gayard was taken to hospital. He left with a contusion to his forehead and a scar that would remain visible for weeks. Whatever that moment leaves inside a man, the kind that no medical report has a category for that went home with him too, here is where it gets worse. When Dukes cuffed Gayard and brought him to his feet, Gayard, head bleeding, said, "Y'all bust my head down. You throw me down." Dukes responded, "I sure did. You weren't listening." Not regret, not concern, not the reaction of a man who understood he had crossed a line that should never have been crossed. Certainty. Almost satisfaction. "I sure did." Then Dukes walked over to explain himself to his supervisor, and what he told that sergeant is one of the most remarkable moments in this entire case. He said Gayard had a stick, and he thought it was a gun. He said Gayard failed to comply. He said both he and Gayard simply went to the ground together. He did not mention the stomp. He described a man who fell, not a man whose head he had driven into concrete with his boot. He stood there and lied. His colleague, Sergeant Aquil Polidore, was standing right there. Her body camera caught everything, and when Dukes finished his version of events, Polidore looked directly at the supervisor and said, "He is not telling the truth." Dukes kicked Mr. Gayard in the neck. In her written report, Polidore noted she had asked multiple times whether Gayard needed medical attention. Neither Dukes nor the other officer answered her. She wrote that she was in disbelief over what she had witnessed. Sergeant Polidore did not look away. She did not close ranks. She told the truth, on camera, in writing, while Dukes was standing right there. That deserves to be said clearly and remembered. Let us pause and examine what was happening legally in that parking lot. Under the Fourth Amendment of the United States Constitution, all citizens are protected from unreasonable seizures, including the use of excessive force by law enforcement. The legal standard, established by the Supreme Court in Graham v. Connor in 1989, requires that force used by an officer must be objectively reasonable based on the circumstances as they appeared at the moment, not in hindsight, but in the moment. The relevant factors are the severity of the crime suspected, whether the suspect poses an immediate threat, and whether the suspect is actively resisting or fleeing. Apply those factors here. Clarence Gayard was suspected of nothing more than possibly carrying a weapon based on a single unverified 911 call. He posed no immediate threat. He was on his hands and knees. He was not resisting. He was actively, visibly attempting to comply. There is no reasonable reading of Graham versus Connor under which stomping on the head and neck of a man already on the ground constitutes lawful force. The department's own investigators agreed. The duty captain described Dukes' use of force as excessive. The internal report formally documented that Dukes' account was inconsistent with the body camera footage, a written finding, from inside his own department that he had lied in his official report. That is not an allegation. That is a documented institutional conclusion. 2 days after the incident, Orangeburg Department of Public Safety Chief Mike Adams terminated David Lance Dukes, stating publicly that his actions fell outside the department's use of force policies. The case was then referred to the South Carolina Law Enforcement Division for criminal investigation. SLED determined that Dukes' actions were likely to produce death or great bodily injury. On July 31st, 2021, 5 days after the stomp, Dukes was arrested and charged with first-degree assault and battery. He was booked into the Orangeburg County Detention Center and released on a $10,000 bond. If convicted, he faces up to 10 years in prison. The criminal case is still working through the courts. In November of 2021, the city of Orangeburg reached a $650,000 civil settlement with Clarence Gayard. The city issued a formal apology and committed to establishing a citizens' task force for oversight of law enforcement interactions with the public. Gayard's attorney, Justin Bamberg, noted he had rarely seen a city accept responsibility so quickly and work so visibly to prevent recurrence. Now here is the part of the story that the press releases left out. David Lance Dukes had a history. According to records from the South Carolina Criminal Justice Academy, he was originally hired by the Calhoun County Sheriff's Office in 2012, but was removed because he could not pass the mandatory academy test. He rejoined the force a year later. By April of 2020, his supervisor documented that Dukes was causing turmoil within the unit, creating a hostile work environment, and was counterproductive to the goals and mission of the department. That same supervisor had personally counseled Dukes on his behavior and conduct at least 6 times. In October of 2020, Dukes was fired from the Calhoun County Sheriff's Office for insubordination. 9 months later, he was standing in a parking lot in Orangeburg with a badge, a gun, and his boot on a man's head. A department hired him anyway, gave him a uniform, sent him into a community where 75% of residents are black, and when that community called 911, a call placed, it later emerged, by a relative of Gaillard who said she had never actually seen a gun and declined to press any charges. David Lance Dukes was the response they got. From a legal standpoint, this raises the question of negligent hiring, a civil doctrine that holds employers liable when they hire individuals they knew, or should have known, posed a foreseeable risk of harm. If an employer can be held liable for ignoring an employee's documented problematic history, the same principle applies to law enforcement agencies. Orangeburg did not create Dukes' record, but someone reviewed it and decided it was not disqualifying. That decision has consequences, legal, moral, and human. This is not unique to Orangeburg. Across the United States, a well-documented phenomenon exists where officers with misconduct records move between departments, sometimes called gypsy cops in policy literature, because no centralized, mandatory functional system exists to flag and prevent that movement. The paper trail was there, the system just did not act on it. After the settlement, after the cameras, after all of it, Clarence Gaillard stood up and said something worth sitting with. Every time I look in the mirror, I see the scar on my forehead and it is not okay. The only thing I want the community to do is change. He did not call for destruction. He did not ask for vengeance. He asked for change from a man who had just had his head driven into concrete by someone who was supposed to protect him. And he said this about Sergeant Polidor, the officer who told the truth. She didn't lie. She told the truth. All officers are not bad. Some are good. He said that. After everything. David Lance Dukes was fired. He was charged with a felony. A $650,000 settlement was reached on behalf of the man whose head he put into concrete. His previous employer had documented his failures in writing 6 documented counseling sessions, a hostile work environment finding, a termination for insubordination, and none of it stopped the next department from handing him a badge. That last part does not have a resolution yet. Clarence Gaillard was trying to get to the ground. He was doing exactly what he was told, at the only speed his broken body allowed. And an officer already fired once, already counseled 6 times, already flagged in writing as a problem decided that was not good enough. The scar on Gaillard's forehead is still there. The criminal case is still pending. And somewhere in South Carolina, there is a hiring process that looked at David Lance Dukes' full record and said, yes, anyway, that process has not been fixed. Not here. Not in enough places. Until it is, what happened in that parking lot on July 26th, 2021 will keep happening. Somewhere else. To someone else. By someone whose paper trail was already writing the ending long before any body camera ever rolled? Drop your thoughts in the comments. Share this if it reached you. Subscribe if you want to stay with stories like this one.
Last time! Drop the knife! Drop it! Fuck!
Oh my God!
Hey! Hey, drop the knife! Drop the knife!
Do you have a taser?
No, drop the knife! Drop the knife! Drop the knife! Drop! Drop the knife! Drop the knife! Woman, you're gonna get shot! Drop the knife! Drop the knife! Drop the knife! Drop it! Last time! Drop the knife! Drop it! Fuck! Fuck!
Any of the units able to free up, head over to 687 Blue Hills Ave. Just need one more car, head over to 687 Blue Hills Ave. third involves 687 suspect. 687 Blue Hood back.
We did things, my man.
Fuck you ain't changed that man for. Nah, fuck you mean with that, bro. The fuck you mean you let that dude have? Yes, you did, bro. You can't do it like your fucking job, bro. Look, come on down here, bro. Stop that fucking dumbass shit, bro.
Drop the knife! Hold on, we have him at gunpoint. He has a knife in his hand. Drop the knife. 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 Craig, just back up. Drop the knife. Just drop the knife. 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 Craig, just back up a little bit. Drop the knife. Drop the knife. Drop the knife. Drop the knife. Craig, just back up, back up, back up. Craig. Drop the knife! Stevie, you gotta drop the knife. We do not want to shoot you. Just drop the knife. Drop the knife! Drop the knife, hon. Drop the knife. Drop the knife! Honey, you gotta drop the knife. You gotta drop the knife. Still hasn't let go of the knife. Drop the knife. Drop the knife, hon. Back up, hon. Just back up a little bit. Stevie, you gotta drop the knife. You gotta drop the knife. You gotta drop it, honey. Drop it, hon. Drop it. It's not that, hon, we don't have to do that stuff. Can we, do we have another taser?
Okay, can you drop it for me, Steve?
Do we have anyone else with a taser?
Steve, can you drop it? Come in. What's going on with you?
Honey, you gotta drop the knife.
Drop it. Just drop it so we can help you. You got a big knife in here. You gotta drop it so we can help you.
Please just drop the knife, hon.
All right, Steve? Steve, you're okay. We're gonna make sure you're okay. Just
drop the knife. Come on.
We're gonna go talk to somebody, okay?
Drop the knife, hon. Do you have a taser? Do you have a taser?
Drop the knife. Drop the knife. Drop the knife.
Stevie.
Mag.
Drop the knife.
Mag, just back.
Drop the knife.
Mag.
Drop the knife.
Drop it! Stevie!
Last time. Drop the knife. Drop it.
You gotta drop it. My man, you gotta drop it. You gotta drop it. We don't want to shoot you. We don't want to, bro. You gotta drop it. Drop it. You don't want to get shot. You don't want to get shot. Come on. Drop the knife. We don't want to do that. Can you just drop the knife for me, my man? Just drop it. Just drop it. Just drop it. My man, you don't want to get shot. Think about it. Drop the knife. We're just going to get you help. We're going to get you help. Just drop it. Just drop it. My man, we're good. Yo, look at me. Look at me. We're here to help you. We're here to help you. Just drop it. Just drop it. We're just going to get you to the hospital. We're going to talk to somebody. Your family wants you to get help. What's your name, my man? What's your name? What's your name? Stevie. What's his name? Stevie? Stevie, can you drop it for me? Stevie, you gotta drop it. You gotta drop it, Steve. You got. Stevie, you gotta drop it. You gotta drop it. You gotta drop it. You gotta drop it. Stevie, watch that.
Stevie, drop the knife. Come on, baby.
Stevie, you're okay.
Stevie, look. They're trying to help you. They're trying to help you.
Calm down, Stevie.
They want to help you. Just drop it and we'll help you.
You ain't hungry?
Stevie, drop it. Drop it. We're going to put the guns away and that's it.
Stevie. It's me and Nate. Me and Derek. You gonna just send me. Drop the knife.
Stevie, just drop it. Just drop it. It's all done, Stevie. It's all over with, Steve.
Good job, Stevie. Stevie, come on.
Stevie.
You gotta drop the knife.
Stevie,
You gotta
come on.
drop the knife.
Look at Sonny.
You gotta drop it, honey.
Yeah, get Sonny, Stevie. Come on,
Drop it, hon.
Stevie, it's over with. It's over with. Just drop it and let's go get help. All right?
It's not that. You don't have to do
Stevie,
that.
drop the knife.
Stevie, you're okay.
Do we have another team?
You're okay. Can you drop it for me, Steve? Stevie, can you drop it, my man? What's going on with you? Drop it. Just drop it so we can help you. You got a big knife in your hand. You got to drop it so we can help you. Okay? All right, Steve? Steve, you're okay. We're going to make sure you're okay. Just drop the knife. We're going to get you. We're going to go talk to somebody, okay? Stevie, just drop it. Just drop it.
Drop the knife.
Stevie, Mac, chill. Stevie, Magnano, chill.
Drop the knife.
Stevie,
Drop
you
the knife.
gotta drop it.
Last time.
Stevie,
Drop the knife.
drop it.
Drop it.
There's the knife.
That's fine. Keep the knife.
Hold on, drop the knife. Drop the knife first. Have him drop the knife. What's his? Hey, throw the knife away. Throw the knife. Drop. Alright, he's coming toward you. Drop the knife! Drop the knife! Yep. I'm not gonna shoot him. Drop the knife! Drop the knife! Drop the knife, please. Drop the knife. Drop the knife. I'm just creating distance. Drop the knife. Taser.
Relax. Hey, you gotta drop the knife. We don't want to shoot you. We don't want to shoot you. You gotta drop it.
Shit is ineffective.
You gotta drop it. We don't want to shoot you.
Drop the knife. Drop the knife. Drop the knife! Drop the knife! Stevie! Drop the knife!
Back up a little bit.
Stevie! Stevie! Yo, Stevie! Drop the knife! Hey! Stevie! Drop the knife! Come on, baby! Come on!
Look, Stevie, look. Let's go get some cream cheese and bacon. Calm down, Stevie. Stevie, just chill out. You ain't hungry? Stevie, drop it.
You gotta drop the knife.
Stevie, it's me and Nate. Me and Derek, we gonna get something to eat. Drop the knife. Come on, man.
Stevie, come on, drop the knife!
Come on, Stevie.
You're good.
Come on, you want something to eat?
Good job, Stevie.
Stevie, come on. Drop the knife.
Gotta drop the knife.
Stevie, come on.
Gotta drop the knife.
Yeah, get something to eat, Stevie. Just drop the knife, Stevie. Okay? Stevie, drop the knife.
Do we have another taser?
You're okay. Can you drop it for me, Steve? Stevie, can you drop it? How many? What's going on?
Drop the knife, Stevie.
We're gonna go talk to somebody, okay? Come on, Stevie.
Stevie, drop the knife, all right?
Drop the knife. Drop the knife.
Stevie.
Drop the knife. Drop the knife.
Stevie.
Mama, you're gonna get shot. Drop the knife.
Steve.
Drop the knife.
Stevie. Stevie.
Last time.
Stevie.
Drop the knife.
Stevie.
On February 27th, 2026, a woman made a phone call. She was not calling to report a crime. She was not calling because she was afraid of her brother. She was calling because she loved him, because she could see he was struggling, because she believed, the way families are supposed to believe, that the system would send help. Her name is Audrey Jones. Her brother's name was Stephen Jones. Everyone who knew him called him Stevie. Stevie never came home. And before this video is over, you are going to understand exactly how a sister's call for help became a death sentence. You are going to understand the law, the failures, the pattern, and the people who are still fighting for answers. If you have not seen my last video about Everard Walker, I will leave it linked in the description, because what happened to Stevie Jones did not happen in isolation. It happened 8 days after Everard Walker was killed in his own apartment on Capitol Avenue. 8 days. Same city, same crisis, same outcome. 2 black men, 2 families that did the right thing. 2 funerals. But today we are talking about Stevie. Before we get into it, if you are new here, subscribe and turn on notifications. We cover stories like this every single week, and you do not want to miss what is coming. Now, let us get into it. Stephen Jones was 55 years old. He lived in Hartford's North End on Blue Hills Avenue. He was known in his community as Stevie, a name that carries warmth, the kind of name people use when they genuinely love you. His sister Audrey described him simply. He was a good person. He was always there for everyone. He was a good brother to me. That is who was standing on that front stoop on the morning of February 27th. Not a criminal, not a threat. A 55-year-old man who was not well, whose family could see it, and whose sister made the hardest kind of decision a family member can make. She called for help. Audrey Jones dialed 911 on the morning of February 27th, 2026. She reported that her brother was experiencing an acute mental health crisis. She told them he had not taken his medication. She was present. She was trying to get him care. Now I need to pause here because I covered this in my Everard Walker video, and I need you to carry that context into this story. Hartford had a program, a real one. The Hartford Emergency Assistance Response Team, the HERE team, was specifically designed to send social workers and peer responders instead of police to exactly this kind of call. The city spent $5 million building it. It had handled over 2,000 calls since 2022. It existed so that a family like Audrey's would not have to pray that the people who showed up at their door would choose care over force. But by January 2026, that program had already been quietly gutted. Weekend coverage eliminated entirely. Evening hours cut. A key partner organization dropped. Federal funding had dried up and the city had not replaced it. So when Audrey called 911 on that Friday morning, The full safety net that should have caught her brother was already fraying at the edges. What arrived instead was police. Officer Josue Charles arrived first. He found Stevie Jones on the front stoop of his apartment holding a knife. He immediately ordered Stevie to drop it. Stevie walked slowly toward him. Officer Charles deployed a taser. It was ineffective. And then Officer Charles said something to Audrey Jones that I want you to hold on to. He looked at her and said, "I am not going to shoot him." Read that again. The first officer on scene, facing a man with a knife, made a choice. He made a promise. I am not going to shoot him. Officer James Prignano arrived next. He kept talking to Stevie. He told him, "We don't want to shoot you. We don't want to, brother. We're just going to get you help. We're here to help you. Just drop it. We're just going to get you to the hospital. We're going to talk to somebody. Your family wants you to get help." Officer Jacqueline Torres arrived third. She asked Stevie to drop the knife. She asked if anyone had another taser. She kept the tone measured. She kept working. For 5 full minutes, 3 officers stood in the street with Stevie Jones. They formed a semicircle around him. They called him by name. They told him he was going to be okay. They did not fire their weapons. 5 minutes is a long time when you are afraid. 5 minutes is a long time when you are holding a position and trying to reach someone who cannot reach back. Those 3 officers held that line. And then a 4th officer arrived. Officer Joseph Magnano pulled up to Blue Hills Avenue as the 4th officer on scene. He was 23 years old. He had graduated from the police academy on March 28, 2025. He had been on the job for less than 1 year. He was still inside his probationary period. He had no taser. From the moment Officer Magnano stepped out of his patrol car to the moment he fired the first shot, 32 seconds elapsed. 32 seconds. While the other officers had spent 5 minutes building toward a moment where Stevie might put down that knife, Magnano arrived, pointed his gun, and within 32 seconds made a decision that those 3 officers had spent 5 full minutes refusing to make. The body camera footage shows what happened in those seconds. Officer Torres asked Magnano if he had a taser. He said no. He pointed his weapon at Stevie and ordered him to drop the knife. Stevie walked toward him. Officer Prignano can be seen raising his hand toward Magnano in what appears to be a pause gesture. He called Magnano's name. "Magnano, Magnano," he said. "Torres said it too." Mag. Magnano fired 9 times. Stevie Jones collapsed in the street. Audrey Jones, who had called 911 to get her brother help, who had stood on that street and watched officers try to reach him, screamed. She had told them he hadn't taken his medication. She had begged them not to shoot. "I screamed at the police, 'Don't shoot him,' she said later. He didn't take his meds, and they shot him anyway." Stevie was transported to the hospital. He died 4 days later on March 3rd, 2026. He was 55 years old. Now, let me put on my legal hat, because there are several questions this case raises that go beyond grief and outrage into the territory of law and accountability. The first question is the use of force standard. Under Connecticut law and the 4th Amendment of the United States Constitution, a police officer may only use deadly force when they reasonably believe there is an imminent threat of death or serious bodily harm. The legal test is not what the officer felt subjectively. It is what a reasonable officer in that situation would have believed. Here is why that matters in this specific case. 3 officers, all facing the same man with the same knife in the same street, made the determination not to fire. They held that position for 5 minutes. Then a 4th officer arrived and fired within 32 seconds. Civil rights attorney Ben Crump asked the question that the law demands be answered. Why did the other 3 officers not shoot? Why did they have restraint? If the situation legally justified deadly force, why were 3 trained officers exercising a different judgment? That contrast is not just emotional, it is evidentiary. In a civil lawsuit, the conduct of the other 3 officers becomes directly relevant to whether Magnano's use of force was objectively reasonable. You cannot easily argue a threat required lethal force when 3 of your colleagues stood in front of that same threat and chose differently. The second question is experience and judgment. Magnano was less than 1 year out of the academy. A criminal justice expert named Mike Lawler, an associate professor at the University of New Haven who helped shape Connecticut's policing standards, noted that experience matters in high-pressure situations. He observed that the first 3 officers were maintaining eye contact, engaging in conversation, keeping what for them was a safe distance. He said everything changed when the 4th officer arrived suddenly. Magnano's rapid engagement with Stevie, Lawler said, highlights the challenges that arise when a relatively inexperienced officer confronts a volatile scenario. The police union pushed back on this. Union President Sergeant James Rutkowski argued that all 4 officers had their guns drawn. that this was a lethal situation and that Magnano did what he was trained to do. But that argument carries its own weight. If a less than 1 year officer with 32 seconds on scene, no taser, and no integration with the existing de-escalation effort did exactly what he was trained to do, then the training itself is on trial. The third question is civil liability. Connecticut's Police Accountability Act is one of the strongest such laws in the country. It creates a state-level pathway around qualified immunity, the federal doctrine that has historically made it nearly impossible to hold individual officers accountable in federal court. Attorney Ben Crump confirmed the family was exploring all civil legal options. A civil lawsuit under Connecticut's accountability law would likely center on excessive force and could name both Magnano and the city of Hartford. The city's potential liability would rest in part on questions of training, supervision, and whether the deployment of an inexperienced officer without a less lethal weapon to an active de-escalation situation constituted deliberate indifference to Stevie Jones's constitutional rights. The fourth question is criminal accountability. The State Office of Inspector General was investigating whether Magnano's use of force met Connecticut's statutory standards. The bar for criminal charges is significantly higher than civil liability. A prosecutor would need to prove beyond a reasonable doubt that Magnano did not have a reasonable belief he was in danger. That is a difficult threshold, but the investigation was ongoing and the community was watching. On March 27, 2026, Hartford Mayor Arunan Arulampalam walked out of City Hall and announced that Officer Joseph Magnano had been terminated immediately. He praised the other 3 officers. He said, "What I saw were 3 officers who exemplified the very best of that badge. 3 officers who worked collaboratively as a team to de-escalate a really difficult situation. And then I saw 1 officer come in, Officer Magnano, late to the scene, not work with his teammates, not de-escalate, and the end result of that was a tragic incident that took the life of Stephen Jones." The mayor said Magnano's performance did not meet the standards expected of the Hartford Police Department. Now, here is the legal detail that almost nobody is talking about. That day, March 27th, was the final day of Magnano's probationary period. Under Connecticut law and the terms of the police union contract, the mayor can only terminate a probationary officer based on performance without triggering the full weight of union contract protections. Had the mayor waited 1 more day, 1 single day, Magnano would have crossed out of his probationary period, and the union's contractual grievance and arbitration machinery would have made firing him exponentially harder. The mayor used the 1 window the law gave him, and he used it on the last possible day it existed. That is either decisive leadership, or it is the bare minimum. You can decide which. But understand what it means structurally. The system was designed in a way that gave the community exactly 1 day to get accountability through this particular door, and that door was always going to close regardless of what Stevie's family deserved. The Hartford Police Union did not take the firing quietly. Union President Sergeant James Rutkowski called the mayor a coward. He said the mayor caved to political pressure and was devoid of any semblance of leadership. He said the shooting was a justified, lawful use of force. He said, "We go to war." When asked what that meant specifically, he said, "We'll find out." That is the head of the union that represents the officers who will respond the next time a family in Hartford calls 911 during a mental health crisis. Sit with that. I need you to step back with me now because Stevie Jones's story does not begin on February 27th, and it does not end with Magnano's firing. 8 days before Magnano shot Stevie, Officer Alexander Clifford shot and killed Everard Walker inside his Capitol Avenue home. I covered that story in my last video. Walker's family had called 211, the Health and Human Services line, specifically to avoid a police response. They still got 11 officers. Walker is still dead. And as of the time this video covers, Officer Clifford remained on duty. He was not fired. 2 black men, 2 families who followed the system's rules, 2 funerals, 1 officer fired, 1 still on the job. The community held the mayor and police chief to that disparity. They issued 5 demands: a public briefing within 7 days, termination of both officers, the Inspector General investigation completed within 6 months, permanent, full funding of the Mental Health Crisis Response Program, full activation of the Civilian Police Review Board. The mayor issued a statement about transparency and accountability. He did not commit to the briefing. He did not commit to firing Clifford. He did not commit to the review board. And speaking of that review board, while the community was demanding its activation, the Hartford Police Union was in the middle of a legal challenge designed to strip it of its power. The union filed a complaint arguing that when the city gave the review board the ability to take misconduct cases to binding arbitration, it violated state labor law. That case was scheduled to be heard by the State Board of Labor Relations in early April 2026. The very mechanisms of accountability that the community was demanding were being litigated out of existence at the same moment the community was demanding them. That is not a coincidence. That is how these systems protect themselves. On March 12, 2026, dozens of community members gathered at the corner of Blue Hills Avenue and Euclid Street, steps from where Stevie Jones was shot. Reverend A.J. Johnson of Urban Hope Refuge Church spoke for them. The pain our community has felt over the last 2 weeks is telling us clearly that our city is in need of care, accountability, and repair. We are not here to inflame the situation. We are here because silence will not heal the wound. Kenneth Green, a former Hartford State Representative and licensed clinical social worker, stood before that crowd and said what needed to be said. Communities need to know that when someone calls for help, the response will be compassionate, professional, and focused on care. That is not a radical demand. That is the minimum that any human being should be able to expect when they pick up a phone and ask for help. Stevie's funeral was held on March 26, 2026 in Bloomfield. Reverend Al Sharpton was there, Ben Crump was there, Mayor Arulampalam was there, and Audrey Jones was there, the woman who made that phone call, the woman who stood on that street and watched what happened to her brother, the woman who said afterward, "If I would have known that they were going to kill my brother, I would not have ever called 911 for an ambulance." Read that again. The sister of a man killed during a mental health crisis is telling the world that she regrets calling for help. That is the damage this does, not just to one family, not just to one community. To every single person who now has to weigh whether calling 911 for a loved one in crisis is worth the risk. That is what was taken from Hartford's North End on February 27th. 2026. Not just Stevie Jones. The ability to trust the phone call itself. Stevie Jones did not die because he was dangerous. 3 officers stood in front of him for 5 minutes and made that determination with their restraint. Stevie Jones died because a 23-year-old officer with 32 seconds on scene, no taser, and no integration with an ongoing de-escalation effort made a different determination. And behind that officer was a system that had already cut the mental health response program that might have meant police never needed to be there at all. And behind that system was a union actively fighting to ensure that when things like this happen, the community has as little power as possible to demand accountability. Stevie deserved a doctor. He deserved care. He deserved the 5 minutes that 3 officers gave him to become more than the worst moment of his crisis. He deserved to walk back into that apartment and take his medication and call his sister and tell her he was okay. He deserved to come home. Say his name. Stephen Jones. Stevie. 55 years old. A good person. A good brother. A man who deserved better from every single institution that failed him on February 27th, 2026. If this video moved you, share it. Drop your thoughts in the comments. If you are new here, go watch my Everard Walker video because these 2 stories are one story. And subscribe because this is what we do. We make sure these names are not forgotten. I will see you in the next one.